queue to get through the one metal detector knowledge arm. So they don't exactly see this.
So should I just start when we're... Okay, let me call the second session to order. My name is Jerry Reichman, and I teach intellectual property here at Duke. We're delighted to be able to work with our students and enjoy the wonderful conference they put on. We just have to learn all from, let them teach us this time, and it's really been wonderful so far, and I think we have a wonderful panel for the afternoon. Our topic this afternoon is the intersection of antitrust law and intellectual property law. This is a very hot topic. We're here for hot topics. This is a hot topic getting hotter, and it's hotter all over the world. The worldwide importance of this topic cannot be underestimated. Many of us have been telling the developing countries for years now that one of the biggest problems that they have is not just coming from the TRIPS agreement, from international intellectual property norms, but because they are very far behind in fashioning an antitrust law for the 21st century of intellectual property law. And we're not getting very far. They haven't taken many steps in that direction. In contrast, the European Union has been acting very aggressively in this area. As many of you know, the chief commissioner was on television, BBC, the other night, shouting at Microsoft and upping their fine to $1 billion. And less known is the fact that they've just had a sweeping investigation direct on with search of leading pharmaceutical companies on charges of keeping generic drugs illegally off the market. So they're taking a very aggressive stance, but they have a different law from what we have. They have the notion of an abuse of a dominant position, which once you establish market power, gives them some options that we don't have. Here, on the other hand, we have a very old distinction between misuse in patent law, which in theory doesn't require market power, and is a common law defense to patent infringement. And over here we have our antitrust law as it pertains to intellectual property, but it tends to be much more restrictive because it tends to look for monopolization and has a higher standard than would be necessary if you had a misuse doctrine in antitrust law. So some of us think maybe we ought to move in the direction of the European Union, but other people think that's a terrible direction and maybe the European Union should move in our direction. So it's a very controversial area, and like most of you, I'm here to learn more about it from our very, very distinguished panel. And let me introduce them to you now, and then we'll just call them up one by one, and then we'll have question and answers with the whole panel at the end. The first speaker will be Dean Williamson, who is a research economist at the Antitrust Division of the U.S. Department of Justice, but is now moonlighting as an academic. And he's over here. Why don't you stand up to identify yourself? He's he's the Victor H. Kramer Fellow at Harvard Law School at the moment, doing research on the design of research and development joint ventures and work on the role of renegotiation in enabling contracting parties to manage long-term relationships. And of course, his studies fall in what is becoming the single hottest area of today is what to do about markets for technology, and he's going to talk to us about antitrust innovation and uncertain property rights, some practical considerations. Then unfortunately, Hillary Green, we were all looking forward to having Hillary with us, in part because she is one of the authors of the famous 2003 FTC report. But Hillary has injured her shoulder and is not going to be able to be here, but it gives us the opportunity we were going to have our own Barak Richman, who teaches antitrust and who deals increasingly with some of these areas, speak anyway, and he will now speak I think at the end of the panel in her place and give us some comments in response to the panel before we go to question and answer. Barak Richman is over here. And then we will hear from David Balto, who I'm particularly happy to see here. David Balto practiced antitrust law for over 20 years in the Antitrust Division of the Department of Justice, the FTC, and in private practice. He is the former policy director of the FTC, and he was involved. He was deeply involved in cases involving mergers of pharmaceutical companies and other issues with the pharmaceutical companies, and we're particularly interested in what he has to say on that topic. He's going to talk about roadblocks on the pharmaceutical competition highway, strategies to delay generic competition. I think that is probably the single hottest topic in this area around the world. So we're very interested in that, and he does work with a lot of healthcare companies now. He's in private litigation now. And our last speaker will be Professor Joshua Wright. Where is Professor Wright? Right? Okay, Professor Wright is over here. He is an assistant professor of law at George Mason University, and he was appointed to the newly created position of scholar in residence at the Federal Trade Commission's Bureau of Competition, where he will serve on leave from George Mason this academic year. You're there now, I take it, right? Right there, okay. So he will bring us the up-to-date word. He's a graduate of the UCLA School of Law, and he holds MA and PhD degrees in economics from UCLA, and he was also a law clerk. He is going to speak to us on thoughts on the limits of the patent hold-up doctrine. So at the end of the day, we should know a lot more about this topic than we do at the beginning. I would call Dean Williamson to the podium. Thank you very much.
Okay, thank you. Oh, I was going to ask how you turn it on, and there it is. Well, first things first, whatever I say, the normal disclaimer is really reflect my views, not those necessarily of the Department of Justice. So it was in November. I'm up at Harvard, and I checked my DOJ email. There was this email that said, "Oh, Professor Williamson," obviously not one of my friends. "We're following up on our invitation to come down here," which I think is great. And what must have happened, it must have been mailed to my DOJ office. But they said, "Well, could you, write a little something about the intersection of antitrust and intellectual property?" I said, "Sure, I can do that." But I felt like a school kid with a, book report due. And I thought, so I have some things to say. And, but I was aware that, haven't people been writing about this for about 10,000 years? 100 years and 10,000 authors, and I think that's about right. So to organize my thoughts, I wrote down on a piece of paper something that looks like this map. So there's this mysterious stuff called intellectual property, and somehow this interacts with antitrust, and then antitrust somehow interacts with the stuff we really care about, which is innovation, and then, of course, intellectual property and innovation interact. And a lot of people have, ask questions like, well, does the intellectual property regime, does it promote or frustrate innovation? And we're going to hear something about that in one of the follow-on talks. We heard about that this morning. How can you, how can we make the, patent system better and all this type of stuff? And then there are questions down here. Well, how do antitrust and intellectual property law interact? And I kind of suspect that antitrust folks are the ones who are mostly writing about this, because they're feeling a little sensitive. Why? Because this has some basis in the Constitution. Article 8 of Section 1 or whatever. And whereas in this, its basis is, starts in not 1290, 1890. And I'm a medievalist at heart, so that's why I said 1290. But so they keep telling these stories. You see all these incantations and very recent stuff by very serious people like Doug Mellabed say, well, no, these things are complementary. They're all about promoting innovation. Now, what I do in this paper is I don't really talk so much. I don't know that they're really much in the way of hot topics. Maybe there's new industries, but the really difficult stuff, I think most of it is not really specific to innovation per se, but it's all this stuff about vertical contracting practices and exclusion. Now, I know that Josh Wright and colleagues over at the FTC and also at the DOJ are busy writing a report, kind of epilogue to the single firm conduct hearings we had a few years ago, and those hearings really do pick up these difficult issues about exclusion. Now, how does that implicate innovation? Well, you have, one question might be, how do you use patents, how do you condition them or selectively license them or refuse to license them to to frustrate rivals. But anyway, so I'm not going to really worry about these types of questions. Instead, I'm going to relabel these boxes a little bit. So instead of uncertain intellectual property rights, let me speak of uncertain property rights. And some authors, Carl Shapiro and others, they write about probabilistic patents, similar concept. And what I'm really interested in is, take for example patent litigation. Many of these things may not go to ultimate judgment, but some do. And when that happens, that's actually kind of surprising, because what you're forcing a judge to do is to delineate claims. And, so a line in the sand may go some way towards delineating beachfront properties, but is a judge going to be any better than a jury or any better than the parties themselves between delineating claims? And I'm going to pull up an example where I think this problem comes up. It's just a very uncertain process. And then instead of talking about antitrust law per se, I'm really going to talk about the process. The question is, what happens when a matter, a merger investigation, say, or some type of antitrust investigation into vertical contracting practices lands on my desk and the desks of my colleagues? What does it mean when somebody invokes intellectual property? And then I'll make one more change here. What's so important about innovation? What's the difference between innovation and, say, just investment in R&D? Because investment in R&D is the stuff that yields innovation, and then why don't we just get rid of R&D and just call it investment? So so this is just my way of begging the question: what's so special about interactions between antitrust and innovation when you could just as well frame it as interactions between antitrust and investment? But I'm going to make one more label change here. And I'm going to talk about collaborative R&D for two reasons. One, I know a few things about it. And two, I think it helps you understand some of the history of the last 20 years, or 25 years really, about what antitrust has had to say about innovation-relevant activities. So oversimply, here are kind of 4 types of propositions. And it's rarely, the first one indicates it's been rarely the case that antitrust has ever marched in and objected to collaborative R&D joint ventures. People have been observing this for years and years and years, and they keep coming up with the one example, which is back from, I don't know, like 1965 or something like that. And then, okay, here's my other point. I anticipated myself. What's the difference between innovation and investment? Well, maybe it has something to do with, partly has something to do with the uncertainty of underlying property rights. And then I'm going to establish this idea that uncertain property rights matters by talking about this example of the diaper wars. And I like this example a lot because it's not all sexy industries, it's not aerospace, it's not electronics, it's not pharmaceuticals, something very prosaic, but nonetheless was an environment in which patents and intellectual property was very important, and there were decades and decades and maybe hundreds of claims, if I recall correctly, that pertained to diapers. Who knew? But and then I'm going to talk about just a one enforcement action where I think this idea of uncertain property rights really informed what was going on. So for starts, okay, yeah, I had some fun making this graphic. Now this picture here, if you're, that guy staying on the right, he really is a war correspondent. That's Winston Churchill in 1899. And so what about these diaper wars? So it's about 1985 or so, and Kimberly Clark and Procter & Gamble filed on the same day claims, patent claims that pertain to elasticized diapers. And about 2 years later, Procter & Gamble, I guess Kimberly Clark, received its patent, and like a year later, Procter & Gamble received its patent, and then the litigation started, and this went on for several years, and they did take it all the way to judgment, and a judge had to decide, had to partition, had to draw a line between all these claims. Now, if you're a prospective licensee, this is important because you don't know, you have to license from one of these guys or both of these guys to produce elasticized diapers. And but there's another possibility. The judge might take this bottleneck of patents and, slice it down the middle and say, okay, there's really two types of diapers out there. There's two sets of rights of way for commercializing this thing, and that's exactly what happened. He said, well, there's variant B, I'm going to assign that to Procter & Gamble, and there's variant A, I'll assign that to the other guys. And since then, for the past 15 years, both parties, both Procter & Gamble and Kimberly-Clark, have aggressively continued to aggressively police their property rights over this thing. So what do we got here? Okay, so then we move to an actual enforcement action. Now, yes, intersections between intellectual property and antitrust are really important. I don't know that very, very many merger investigations. I don't know that intellectual property informs many, many merger investigations, but there surely are lots of other types of things like various contracting practices. Take the whole Microsoft business. That was about vertical contracting practices. But I'm going to just kind of focus on mergers here. And in this matter, you had two firms, 3D Systems and DTM, and they both manufactured rapid prototyping systems. These big machines, which are about 2 times the size of this desk. They'd sell these things mostly to folks in aerospace and auto parts manufacturers. People making machine parts, and they overnight send a CAD file to one of these machines, and it would crank out some prototype. And you wake up in the morning, and there it is. And they each commercialized a different technology, one called laser sintering, and the other one called stereolithography. And they were the only two parties in this country who commercialized these technologies. And they were able to use their patent portfolios to bar other producers in Japan and Europe, from commercializing products in this country. So their patent portfolios were kind of proven quantities. They really did each maintain bottlenecks over the commercialization of these technologies in this country. But there were firms elsewhere who were commercializing this stuff. So they wanted to merge, and one deal that was put out there was like, fine, you guys can go ahead and merge, but we'll craft a licensing decree. That is, you afford to some third party rights of way to commercialize one of these two technologies in this country. And then the question becomes, okay, well, what patents do you put in the license? And that's just the road to a lot of trouble, because what are you going to do? You're going to get a patent expert, and this person's going to sit down and tell you what to put in there. He's no better equipped than the judge, the jury, or the parties themselves, really, to tell you what to put in this license. Instead, we can craft a license the way the parties do, and that is just indicate a field of use. So contracts in this business are really simple. They have a lot of definitions up front, one of them being a field, maybe the field's stereolithography. And then there's the contract, which says, oh, you, the licensee, have the right to commercialize this technology in some geographic area. So that was what the contract was going to be. You, the licensee, have the right to commercialize laser sintering, or the other one, stereolithography, within the United States. And that was the solution. So what hazard did this resolve? Well, suppose you put 40 patents in there, and then post-licensing, the parties pull out another 10, and these 10 other patents may support litigation, or patent litigation, and that could defeat the whole purpose of the decree. Now, I thought I was the first person to ever write about this, but when I was looking around, I did stumble upon this piece by Michael Katz and Howard Shalansky. Now, I think Michael Katz knew about this because he was a chief economist at DOJ when we started this. But they raised a generic question. It's like, well, is this an example of compulsory licensing? And that's kind of interesting, because we don't really want to suggest that. But this, in some ways, I'd like to suggest that this licensing decree is less severe than a normal type of decree by which you might ask parties to divest some assets. So in a normal, I guess a more typical transaction or decree, parties might have all types of production capacity out there, and we just might ask them to divest some of this capacity, divest some plant out there in Wyoming or something like this. Well, here you can't do that because you have the one bottleneck, and to transfer ownership of the bottleneck entails denying access to the guy you just took it from. So a way to get out of this is, of course, just give somebody, is to write a long-term contract, in this case, a license. So let's see, I think pretty much wrap up here. Let me see if I have any other issues. Oh, I skipped over something. Okay. My last remarks. What about collaborative R&D? People don't really know much about collaborative R&D to this day, but I think it was Jay Thomas who indicated that, hey, in the 70s, people were worried about, Japan Inc. taking over the world. Now we're worried about China Inc. taking over the world. So through the 80s and into the 90s, there were all these initiatives to promote collaboration or innovation, and one of them, there was this idea out there, this kind of quasi-Schumpeterian notion that, well, we want to promote this Japanese-style collaboration, which is you get competitors together in the same room and see if they can think deep thoughts together and come up with, and innovate. And but policymakers are naturally worried that antitrust, might not look in a very friendly way on this type of collaboration between competitors. But then you have Mariko Sakigibara come along, and she's a researcher at the business school at UCLA, and she's made a career of looking at Japanese consortia for the past 20 years. And she discovered that not even Japanese consortia followed this purportedly Japanese model. And if you start looking at these collaborations, they really don't involve direct competitors getting involved, even in this country. And so a colleague of mine, we've been digging around. I think this issue here, subject to a lot more research, but because what I'd really like to be able to say is ventures typically do not involve direct competitors, or maybe they sometimes do, but that's too strong a statement. So need some more work. But in any case, these types of results are consistent with this observation that antitrust hasn't very often gotten in the way of collaborative ventures. And I'll leave it at that. Okay, thank you.
Thanks. I wanted to thank the staff of the Law Review and everybody else who helped organize this for being nice enough to invite me to speak. I wanted to start off with a commercial. I know many of you are intellectual property students, and I want to tell you that there's another world beyond intellectual property. There's antitrust, and I want to give you 3 reasons. 3 reasons why you might consider a career shift. Take Professor Richman's class. By the way, I get $5 for each one of you who sign up today. And practice antitrust laws. First of all, for those of you who decide to become antitrust lawyers, realize that in life you will not be intimidated by your colleagues who have either an engineering or a biology background. So those people who studied, liberal arts subjects, abandon IP now, go join antitrust, where those people who have the more hard science background will have no advantage over you. Second, I don't know about you, but when we were talking about divisionals and continuation process and all those kind of things, I was just on the edge of my seat. You will not have to know about the obscure process of the PTO should you decide to become an antitrust lawyer. Finally, for those of you who don't like the deeper recesses of your library where the decisions from the 1850s are published, don't worry about antitrust. It was enacted in 1890. The Roberts Supreme Court is in the midst of totally revising antitrust law, so you will not have to read any decisions, probably even any 20th century decisions, in another 2 or 3 years. So keep that in mind. My topic today is about generic pharmaceutical competition, and it's sort of like, you're probably sitting there, what's it doing in here? I mean, generic companies, first of all, generic markets are the model of competition. There's easy entry. There are lots of firms that readily compete. price is readily competed down to marginal cost. It's an antitrust enforcer's dream, but from an intellectual property perspective, it's probably an aberration. I mean, there's no intellectual property rights that are protected. Indeed, we have this complex regulatory system set up so that at some point, some anointed point, generic firms are permitted to enter the market. So why is this something worth talking about at an antitrust intellectual property context? Well, I think that's because it shows you some of the difficulties we have both in creating incentives incentives for people to invent and create new products and giving those intellectual property rights, but at the same time trying to orchestrate competition by creating limits to those intellectual property rights. And for those of you who think it's really hard to do that in the normal patent system, welcome to the pharmaceutical industry, where you have an additional regulatory structure, the Hatch-Waxman Act, which tries to orchestrate this process of allowing competition to bloom. By the way, and that's why I think this topic is a very interesting one. Let me go and say something just generally about IP and antitrust. And, every time, should you take an IP antitrust class, every morning you have the Pledge of Allegiance. You start off and say, IP and antitrust have the same goals. We both seek to go and, improve welfare and stuff like that. Don't believe that for a second. That is just absolutely wrong. I know it's absolutely wrong because I'm a former enforcement official. And one thing that struck me, especially when we began investigations in the pharmaceutical industry, was how holders of intellectual property thought that provided for them immunity from antitrust enforcement. As an antitrust enforcer, there's a bad side to antitrust. You have to look at lots of documents. But as an antitrust person, you go through thousands and thousands of pages of documents. You look for that hot document. Once you find it, you run around to all your colleagues and say, see, we've got this guy. That's what Dean is going to go back to doing in September. That would be really hard in most industries. It came to branded pharmaceutical companies, it was a cinch. I mean, my favorite document, when we began looking at branded pharmaceutical companies, they had a list of 10 ways to extend your patent life. And in fact, some of these practices, an attorney wrote a law review article about, and it was basically about how you could abuse, one form of the FDA regulatory system to go and effectively extend your patent life, which made my life just a heck of a lot easier because I didn't have to come up with creative theories about why these things were antitrust violations. Let me talk about the three topics of, unfortunately, these companies are relatively smart. So they've come up, and the FTC and several private plaintiffs and state attorney general challenged in the late 1990s and early 2000 a lot of these practices. The savings are astronomical. I mean, the savings to consumers from these antitrust challenges are over $10 billion a year. Seriously, over $10 billion a year. But pharmaceutical companies are bright, and they've come up with different approaches to try to extend patent life improperly through a variety of strategies. And it involves this mix of, this complex mix of the incentives to innovate, but yet having incentives for generic firms to challenge those patents. I should have said that earlier. The regulatory structure, the drug structure is unique. What we do is we create the generic pharmaceutical company when it has taken some experimental dosages of the drug and has invented a version of the drug, goes and knocks on the branded company's door and says, I'm ready to enter the market. And the branded company then has 45 days to file a lawsuit against the generic company to keep it off the market. So there's sort of like a Virginia reel. That's a regulatory Virginia reel that's created that you expect the parties to go through. And in the course of the litigation, the generic company is going to try to demonstrate that its drug is the patent's either invalid or that its drug doesn't infringe the patent. So there's this necessary act of infringement, this necessary act of patent litigation. But this all creates these wonderful potentials for strategies for branded firms to engage in to keep the generic firms off the market. Let me talk about 3 of them. The first is product life extensions. Now, we all know new and improved. That's what really gets us interested. It's that next version of the Sony Walkman, or what's a Walkman, Dean? Well, whatever it is, the iPod, or something like that we all look for. And product innovation is necessarily seen as something good, but the branded firms can use product innovations or product line extensions to create a number of obstacles to generic competition. Let me give you an example of this. This is a challenge of an FTC merger. SEMA and Cephalon made this drug. They're 2 generic drug companies, two drug companies which made a drug for the treatment of breakthrough, for the treatment of pain when you receive cancer treatments. Cephalon had the patent over a branded drug, and SEMA was developing a rival drug. Cephalon wanted to acquire SEMA for the purpose of going and switching the market to SEMA's drug because their drug was about to go off patent. The FTC intervened in this case and said that merger would be anti-competitive unless Cephalon provided a license to a generic drug firm so that generic drug firm could effectively enter the market with its copy of Cephalon's drug. Let me give you another example, a hotly litigated case. This involves the drug Tricor and litigation brought by Teva and Impax against Abbott Labs. It's about $1 billion drug to lower cholesterol. When Impax and Teva succeeded in patent litigation, each time during a long series of patent litigation, they would succeed in patent litigation. Abbott would reformulate the drug and say, okay, that's fine. Now the drug, the drug has these new capabilities of something. The last time Abbott changed the drug, they changed it from a capsule to a tablet, suggesting that the tablet version didn't have to be taken with food and that there were some improvements. Ultimately, Abbott, Impax, and a number of consumer groups brought antitrust litigation against Teva, and consumer groups brought antitrust litigation. It wasn't just that Abbott went and changed their product, but they also did other things to forestall the ability of Teva and Impax, generic pharmaceutical manufacturers, to enter the market. They removed all the old product from the market, all their existing branded product from the market, and then there's this entity called the National Drug Data File, and for you to effectively market generic drugs, the branded drug has to be listed in the National Drug Data File, and needless to say, they changed the listing in the National Drug Data File to obsolete. This case comes before Judge Jordan in Delaware, and Abbott says, this is a product innovation. You can't second guess whether or not what we're doing is valuable. And the error costs of punishing innovation are so great that there should be a per se rule of legality, unless you can show that that there's really no product improvement, there's no evaluation you really can do there. Well, the court rejected that standard in a motion to dismiss, and this litigation continues. The court said the position taken by Abbott presupposes that there's an open market for competition and that consumers have an unfettered choice. But the actions that Abbott took to go and withdraw the product from the National Drug Data File and withdraw the existing product on the market removed that degree of consumer choice. And that case continues. A second type of anti-competitive conduct, again on the cutting edge here, involves citizen petitions. I guess, we have trouble with this concept at the FTC that there's this First Amendment and that gives you the freedom to go and petition the government. The FTC always had problems with that. Anyway, so the FDA process, like some other agencies, permits you to file citizen petitions. By the way, there are like 4 or 5 federal agencies that permit citizens to file petitions. The FDA process is abused in a magnificent fashion that no evil monopolist, not even that guy in the movie It's a Wonderful Life, the banker, I can't remember his name, not even he could think of. But look, from an antitrust perspective, the abuse of a regulatory process is like the most pernicious form of the most pernicious type of activity, because if you secure a monopoly from the abuse of a regulatory process, nothing can displace your monopoly. You can't go and invent a better product and all of a sudden displace that monopoly. So that's why antitrust enforcers look at that so seriously. There's a huge problem right now with the citizen petition process. Since 2003, there have been hundreds of citizen petitions filed, typically by unnamed entities, which, if you go look below the covers, are funded by the branded pharmaceutical industry. These citizen petitions are filed at the last moment, just before generic entry is about to occur. And according to my latest statistics, the entities that file citizen petitions prevail in like 4% of the citizen petitions, which is worse than Alex Rodriguez's batting average in the playoffs. So this again is an area where antitrust enforcement, I think, really needs to pay considerable attention, because again, that potential abuse of the regulatory system is problematic. Let me briefly talk about authorized generics, because Jay mentioned that earlier. The incentive you might ask, what is the incentive for a generic pharmaceutical company to spend the time, effort, and expense of challenging a patent in court? I mean, that's obviously a valuable process, at least to an antitrust attorney. And it seems like a valuable process to go challenge a patent that otherwise may be invalid, or to invent a drug that does not infringe. The reward for that is a period of 6-month exclusivity that the generic firm receives for challenging the patent. In the past 2 or 3 years, branded pharmaceutical companies have been entering into alliances with other generic companies to enter the market with what they call an authorized generic the moment that generic competition begins, the moment that the party that successfully challenged the patent is about to enter the market. You can see why that would be problematic. Just as anybody would be concerned about the diminution of the rewards that a brand name firm receives for creating a new drug, anything that would diminish their period of exclusivity, the period of exclusivity of the generic firm is diminished because of this strategy. Now, could this strategy be successful? Let me give you an example, since I'm in North Carolina. After World War II, cigarette manufacturers faced the increasing threat of black label or generic cigarettes. In response to the emergence of black label cigarettes, these branded manufacturers came out with their own black label cigarettes and drove prices below marginal cost. Ultimately, they drove the other black label manufacturers out of the market, and they kept them out of the market for over a decade. This practice was challenged by the Justice Department in a successful case against the cigarette manufacturers. So keep in mind, I think the intersection between antitrust and intellectual property is increasingly important. Courts from Jay's presentation, it's really important to see how the Supreme Court, not that other court that doesn't know how to read law review articles, but the Supreme Court is recognizing the important competition factors in decisions like KSR and eBay. Moreover, in your typical IP litigation, antitrust counterclaims are very common. So it's critical to go and understand those competition concepts. Take Professor Richman's class, even if you don't want to be an antitrust attorney, and use those concepts as you practice IP law. Thank you.
Okay. So I'm going to talk about a fairly generic title for a talk. Limits on the patent holdup doctrine. So some thoughts I'm overselling a little bit. One thought, right? There should be limits. I'm going to talk about a case that suggests maybe there are fewer limits than there were a month or two ago. It's an FTC enforcement action, and I'm going to criticize it a little bit. And so they are writing my current paycheck, so I'm going to give a little bit longer disclaimer than normal. What I say about the case isn't the opinion of any of the commissioners, the commission, the chairman. Well, the chairman resigned a couple days ago. She wrote a dissent in the case. She'll agree with some of what I say. But the commissioners and the majority probably won't. In addition, I'm going to linger on the disclaimer for a couple more seconds because the case is still open for public comment until, I think, April 22nd. It was supposed to be closed for public comment by the time I gave the talk. It's not, so please believe me that everything I say is just what I think. Okay, so there's a case called FTC versus NData. There's a consent decree that the FTC and the parties signed about a month ago, which extends what I'm going to refer to here as patent holdup doctrine. Patent holdup doctrine, the previous two talks we got a nice 30,000-foot view of important issues at the intersection of antitrust and IP. And then we narrowed down a little bit more to issues and with generic competition. I have a specific problem in mind, a patent holdup problem, patent ambush, it's called sometimes. Now, the FTC has been particularly active in enforcement with patent holdup. The Rambus case is pending on appeal. There's Dell, Unical. There's some private litigation going on right now with Broadcom and Qualcomm. There's some of this overseas with Rambus and Qualcomm. Big problem, patent holdup, figuring out how to apply antitrust standards. What comes out of this line of cases is that, in general, deception or misrepresentation is a necessary condition for an antitrust claim. There's got to be some misrepresentation, fraud, omission, intentional omission, knowledge about a patent that reads on the standard. Necessary condition in all of these cases. So if you were providing counsel to your client in the standard setting process, there was some advice you could give them in terms of a safe harbor. You could say, don't lie, disclose, and you'll be okay. You won't get treble damages. Antitrust has a pretty heavy hammer in terms of treble damages and private follow-on litigation and the like. But what about antitrust liability in the absence of deception or misrepresentation? No such luck in the case law outside of the SSO context or not. And with cases with deception and misrepresentation, even there, you had a little bit of a tilting in the doctrine that said, look, we're not too concerned that misrepresentation or deception is going to hinder the competitive process. And so here's what we're going to do. You're going to have to show competitive effects. You're going to have to show, as part of your claim, that the harm here couldn't be resolved by more information from the other party, something like that. So part of the claim was show prices went up, show consumers were harmed. If your complaint was about deception or misrepresentation. So that's sort of the backdrop. In the SSO context, courts have dipped into that body of law, misrepresentation and deception, and said, this can be an antitrust claim. I mean, that's what comes out of these cases, and we're especially concerned about the competitive process being harmed in the standard setting process. In cases like Rambus, the FTC says there was misrepresentation, it was intentional, that we can show competitive harm, we win. We'll see what happens on appeal, but that's basically the contours of the doctrine. So the last little bullet point was a little bit question begging. Is there antitrust liability without deception? That's what NData is about. So NData, there's a disagreement on the facts between the majority who find an antitrust violation and the two dissenting commissioners who don't. So I'm going to give a really basic story about the facts. The consent decree finds a violation of Section 5 of the FTC Act. There is a big backdrop debate here. I don't know how many folks have an antitrust background, but we can talk about it in the Q&A if anybody's interested, about whether or not Section 5 of the FTC Act should operate independently of the Sherman Act. So can there be things that are FTC Act violations that aren't Sherman Act violations? It's clear in theory that there can be. The current chairman, as of 2 days ago, was against this. The previous chairman was against using the FTC Act in this manner. There are several commissioners who are on the record in speeches and such saying, well, wait a minute, even if something's not a Sherman Act violation, maybe we should be using our FTC Act authority to get there. So the fact that it's a standalone Section 5 violation is important. I don't want to get too bogged down in the details of that, but we can talk about it in the Q&A. But long story short, there's a company, National, who has a technology, has to do with the Ethernet standard. It's auto negotiation technology, and National gets its technology adopted by the IEEE with a commitment to license for a one-time fee of $1,000. Unlike the previous strand of cases, there's no allegation here that in 1994, when NData got in the standard, that they did anything wrong. There's no allegation of misrepresentation. They disclosed that they wanted to get patents. They later got the patents. No discussion of misrepresentation, omission, fraud, bad conduct in the sense of the previous line of cases anywhere. National assigned, there's a nice contract law hypothetical here that doesn't end up being too important for the commission's decision. In fact, they ignore most of this. National assigned the rights to another company called Vertical in '98. Vertical departed from the $1,000 commitment in 2002. They went to IEEE and they said, let's renegotiate to a RAND commitment. Let's renegotiate from the $1,000, which basically nobody paid. People just used the technology and said, sue me. And IEEE didn't object. Vertical assigned the right to NData. FTC sues NData. We get our consent decree. Okay. The opinion is really interesting. I'm going to point out some spots in the opinion that I think are a little bit alarming from the perspective of whether or not there are any limits to this patent holdup doctrine, or whether we should be worried about removing this sort of no deception, no misrepresentation safe harbor. So here's the way the majority characterizes the conduct. They say it's reneging on a prior licensing commitment, and it violates Section 5 as both an unfair method of competition and an unfair act or practice. There's sort of two ways you can get an FTC Act violation for Section 5. The conduct here, which is, remember what the conduct is. It's going back to IEEE and saying, remember that $1,000 commitment. We'd like to change that to a RAND commitment moving forward. It's oppressive and coercive. There's no doubt that that type of behavior harms consumers. And there's even this confusing line. Early in the opinion, the majority statement says, there's no allegations of misrepresentation or omission. Later in the opinion, it says, bad faith or deceptive behavior that undermines the competitive process can also end up producing consumer harm. Not sure what this paragraph does, if they've said this isn't bad faith conduct, or doesn't fit our bad conduct requirement in Section 2 for the Sherman Act, but it's in there. Two commissioners, the chairman and Commissioner Kovacic, dissent. Commissioner Kovacic carves out a really narrow objection to the majority statement. The majority statement has a line in it that says, look, don't worry about the stuff about this being used as precedent for follow-on actions and treble damages and all that scary antitrust stuff. Don't worry about that because this is a FTC standalone action, and that's not going to happen. Kovacic says, well, slow down. You've got all these state baby FTC acts that people care what the FTC does in these cases. People care in the states. People care overseas. And we have a significant departure from our prior line of reasoning in these cases. And so this matters. Commissioner Kovacic says somewhere in the opinion, this matters so much that there's no way that we can close this consent decree with the majority statement as written. You have to change it. I hope he's not holding his breath. I don't think that's going to happen, particularly now with the change in the structure of the commission. It's now 3-1 instead of 3-2 by the time the public comment closes. Chairman Majoris says some points that are more akin to the line of criticism that I'm going to raise here, which is under the FTC Act for standalone violations, one of the things you've got to show, and this is the safeguard that comes out of that misrepresentation line of cases, you've got to show consumer harm somewhere. And so this is a limitation that's supposed to apply even when we ditch the Sherman Act and use the sort of standalone Section 5 approach. We've got to show harm to competition. I read you the quote from the majority statement. It says this is oppressive, it raised prices. There's no doubt it raises prices. It says somewhere else, there's a great line in the first paragraph about how the conduct will raise the prices of computers to everybody and their brother and sister. So Chairman Majoris sort of details, look, nobody took out the license. No one ever took out a license for anything other than the $1,000 rate. And there were 3 people who took the license on the $1,000 rate, none of whom paid. Right? They just entered agreements. And Data had to sue some of them to get the money. There's some assertions about competitive harm. Nothing in the record is essentially what her dissent is about. And this gets into what I think is the central critique about unhooking, if you will, antitrust liability from a showing of consumer harm. It's in that misrepresentation fraud line of cases. It's there for a reason. It's there because we worry about false positives for stuff that really doesn't harm the competitive process. We worry about chilling behavior. We worry about stopping people from entering into these agreements in the first place. Here, the rule seems to be, even in the absence of bad conduct, you evade a price constraint in a contract, that's a sufficient condition for antitrust liability. And think about that. You sign a lease with your landlord with a bunch of terms in it. You move your stuff in. It's going to cost you a lot of money to move. Your landlord engages in landlord-tenant holdup instead of patent holdup and says, you know what, I want to raise the rent $50. I want to charge you for parking, $50 a month. A lot of times it pays them to do it because the cost to you of moving, you've made specific investments, you accept and you get held up. Now, most people wouldn't call this an antitrust issue. This case is distinguishable. It's the SSO context, where we're worried about displacing competition in the standard setting context, right? But the problem is these distinctions don't necessarily justify getting away from the harm to competition requirement. That's at the heart of the standalone Section 5 stuff, the Section 2 stuff. And so what the chairman worries about is that what we've done is really open the door here to basically any SSO commitment gone wrong being an antitrust violation, getting these follow-on actions, et cetera. So I don't have the answer to any of these things, but these are the questions I think the case raises. Is there going to be a new era of standalone Section 5 enforcement? 3 of the commissioners have gone on the record saying yes. 1 of them that said no is now gone. Probably yes. Why wasn't there a Section 2 claim? You need harm to competition. The majority says it was there. They just assert it. They say don't worry about follow-on actions on the Sherman Act, but they say everything that you need for a Section 2 action was there. They're just being nice and not suing on that theory. In any event, maybe all of this changes with the Rambis decision, but I think it opens some real questions about where the FTC is going on patent holdup. Thank you.
Hi, I'm Barak Richman, and to continue this tradition of disclaimers, the views expressed in this presentation do in fact represent both the FTC and the Department of Justice. In fact, I'm also speaking on behalf of the State Department too, and the President of the United States. What was actually funny about this is that I was originally, I'm of course filling in for Hillary Green, and one idea is I would give her a presentation. So in fact, I would be speaking on behalf of Hillary Green. I'd be expressing the views of Hillary Green. In which case, I'd be wondering if she'd be expressing my views or I'd be expressing hers. But one thing I am not doing, and this is because I am an antitrust professor, I am not expressing the views of the previous panelists, because competition is the paradigm. And agreement is nothing short of collaboration and collusion. And dissent is what makes the consumer better off. So therefore, even if I'd like to agree, and as much as I in fact do agree, I am prohibited from agreeing from the previous speakers. So therefore, it will be my job to deconstruct, or really destruct, destroy all of the previous comments and create lots of questions and therefore intellectual competition for the Q&A session. The truth is that's actually really hard to do because they're really smart people, and I think there's actually more truth and more accuracy than anything else in what they're saying. But here are a couple of comments. There's an interesting paradigm that's set up with Dean's and David's talks. Dean says, well, there is this it's the panel. The title of the panel is there is an intersection between antitrust and intellectual property. And the big question is whether there are complementarities or tension. David takes a normative take on that and says, look, there's actually a lot of areas where antitrust can help intellectual property. And I will push that a lot farther in the following sense. I think that antitrust can dramatically improve intellectual property writ large, and intellectual property law has nothing to add to antitrust law. All right, so what do I mean by that? It's not just about competition versus property rights and monopolies. And it's not just about incentives to innovate at all. What we have in the paradigm of antitrust law is rules that try to be minimally invasive and expand competition. What we have in intellectual property is hyper-intervention. We have a completely constructed market. It is desperately invasive. It's terribly intrusive. Even when we're trying to fix problems, we often make problems worse. This is actually, I think, what both Dean and Josh are talking about in their specific case studies. So let's talk about some specifics. And I actually want to talk about David's talk, and then I want to go into Dean's and Josh's. So David's talk, first of all, it's a magnificent talk, especially that part about taking antitrust. And actually, I think we might have some dispute on the royalties agreement, which is part of the theme of my talk, actually, where these royalties agreements really are actually anti-competitive. But David gives 3 examples, and I strongly agree with 2, and I think 1 is a little problematic. And it's not problematic because it's a bad policy idea. It's problematic because it highlights how intellectual property law and thinking like intellectual property lawyers can really pervert the real principles and real objectives of antitrust law. So maneuvering between or within the interstices of patent law to extend and expand patent life extension is a real problem. There's no question about that. Expanding a regulatory barrier to entry without any pro-competitive justification is truly, truly antithetical to both antitrust law and, we would say, any design to expand consumer welfare. Similarly, when a regulatory agency is duped and makes bad decisions because it's trying to be responsive to democratic impulses, this is the citizens' petition story, that also is dramatically bad. But let's make sure we keep our eyes on the forest and not the trees. What's problematic about both of these problems? It's regulators trying to fix problems. It's regulators trying to be responsive to citizens and therefore erecting regulatory barriers to entry. It is a very dysfunctional regulatory regime that tries to define the limits of patents, and in trying to fix it, it does nothing other than stifle competition to challenge the patents themselves. The branded genetics story is a little different, and this gets into another larger paradigmatic problem where the main take-home lesson is think like an antitrust lawyer, not like an intellectual property lawyer. When we think about brands, for that matter, when we think about patents, we're looking at the wrong thing. We want to a large degree, the Intellectual Toolworks case was precisely about this. We don't want to think about patents as market power. We want to think about patents as particular regulatory barriers. When we think about patents, our policy objective is to limit the extent of the patents. And only by that do we think we can expand competition. In fact, especially in pharmaceuticals, what we see is competition really begins long before the expiration of a patent life. When a truly innovative drug that does something new, and of course is protected by a patent, enters in the market, we see follow-up drugs that are patented and therefore have some kind of regulatory protection, but they nonetheless are within the same market definition. The market definition is not defined by the patent scope, it's defined by consumer demand. And we often see the diminution of the markups of the market leader through challenges in the marketplace by other brands, by other patented drugs. What's the take-home lesson? The take-home lesson is if you think like an antitrust, if you think like a patent attorney, you're going to be going to the PTO and you're going to be going to the Federal Circuit and you're going to be arguing within this regulatory bureaucracy to try to construct a regulatory structure for competition. Whereas if you were an antitrust attorney, you would be going to the marketplace, and you would be going to use market definitions, market mechanisms to limit the power of a monopolist. It's a much better, as far as social welfare goes, it's a much better approach. So thinking about brands and thinking about patents really might be more hurtful than helpful, more destructive than beneficial. Having said that, of course, David's exactly right, you got to take antitrust. So the Dean's talk and Josh's talk raise up 2 similar problems that really highlight the overarching morass that we're in when we think about how to organize our markets for innovation and therefore you could say our protection of innovation. At the heart of Josh's talk is the process of setting standards. Now you can think, if you were thinking like an intellectual property attorney, you would think, okay, well, let's think about what standards there are. Once you have standards, then you can, you know what is infringible, what is permissible, what is impermissible. You can think of the scope of what patents are valuable and what patents are not valuable. And therefore, you, of course, think about this patent holdup problem, which is, I guess, the overarching albatross to intellectual property attorneys. And this, of course, is the problem that Josh is trying to figure out how to solve. Of course, standard setting in the eyes of the antitrust attorney is pernicious from the start. It's competitors coming together and agreeing how to construct the market. Now, the intellectual property rights people who see network externalities see this as necessarily a really desirable thing. It's a way of expanding social welfare. You know, once you agree on a standard, everybody can build upon it, and you have all these positive externalities. You might, and sometimes technological details, technological structures do create positive externalities, but those are all at the expense of really foundational competition. And once you start seeing the standard setting process from the beginning as pernicious or certainly troubling, which is what an antitrust attorney would do, then you would be far less permissive of the results of these decisions. And I might say that maybe that's why I think Josh is right in the end. I think that keeping your eye on consumer welfare really is where we should, is really what should motivate how we implement decisions, how we implement rules. Having said that, you can understand where an inherent distrust of standard setting would lead to a real concern about the possibilities of deception, even if there's no evidence deception was actually troubling to the market. The antitrust attorney knows what happens when competitors get into the same room together. And intellectual property attorneys are more sympathetic. They call it collaboration. We call it collusion. Now, Dean's talk, I think, speaks to something equally as foundational. It's a very interesting story about what happens when intellectual property rights become uncertain. Now, there's a very rich intellectual tradition that he's speaking to. This is the intellectual tradition. All of you who know intellectual property rights will know this very well. The argument is this: we only can invest on property rights that we know are certain, that we know are firm. If you reduce the certainty of intellectual property rights, we're not going to invest upon that property. The classic example is, if I don't know that I own that hilltop, I'm not going to build my castle upon that hilltop. I have to know that that's my property before I build upon it and before I improve it, to improve my own welfare and therefore to improve everybody else's welfare. So what you have in a patent dispute, where we are talking about intellectual property, where potentially because of this very troublesome regulatory structure, property rights are necessarily less certain, what we have is a dispute. A dispute in the world, in the eyes of an intellectual property attorney, is very troubling. My goodness, there's no certainty. This is really problematic. We've got to figure out how to resolve this dispute. I know, let's divide it in half. I'll have one rights, you have another rights, we'll come up with a licensing agreement. We will resolve the uncertainty of property rights with these very clever Williamsonian contractual arrangements. And that will resolve the problem of uncertainty. What does the antitrust attorney say to this? I liked it a lot more when you guys were fighting each other. Now that you've come up with an agreement, this is collusion. Not only have you divvied up this property right, but you've essentially set up a duopoly with additional barriers to entry. You've made it harder for the third guy to come in. Moreover, if you had a situation where there were, say, two patents and we didn't know whether or not they were the same patent or the different one, if you had a situation where the parties agree they're different and they have some kind of cross-licensing agreement, that also prevents the third party to do what another colleague in our faculty, Jamie Boyle, often talks about, which is the real value from intellectual property is not building upon it, but building off of it, creating synergies between intellectual property rights, creating combinations of rights. Once you have a patent agreement that's solidified by a licensing agreement, you prevent the third party from creating combinations. So what do we have here? We have, through the lens of an intellectual property attorney, we see the importance of making things clear. We see the importance of making sure that there are not multiple paradigms and not undesirable or excessive investment. We see a desire to create a regulatory regime where we can organize and clearly define patent rights, where we can make a very explicit quid pro quo exchange with the innovator. We give you a legal right in exchange for innovation. We see a regulatory regime that tries to adjudicate very interventionistly, very invasively to resolve these problems. And we essentially see a statist economy. The antitrust attorney says, I don't like any of this. I don't like it when parties come together and try to come up with collaborations. I don't like it when they come up with collaborations in the regulatory process, in the judicial process, or in the private standard settings process. I don't like it when they come up with agreements. I want to see them fight. And I definitely don't like it when everybody sees the world through lenses of patents or even brands. We must see the world through the lens of the consumer, through the lens of competition. Therefore, not only do I recommend that you take David's advice and you take antitrust, but I strongly recommend that you take antitrust before you take intellectual property. And when you take intellectual property, you repeatedly cite these principles of antitrust to your intellectual property professor. You will find a very receptive audience here at this law school among the intellectual property professors, and sure enough, I think eventually everywhere else also.
We're going to take a 10-minute break and then meet back at 3:25 for the question and answer session. Thank you.